Welcome everyone to the third Oil and Gas Academy session of this summer. I'm Suzanne Hopkinson and I'm a director in Brodies Oil and Gas team. Today's subject is Demystifying International Arbitration. We hope you'll find this session useful. So let's get started. Ken Macdonald is speaking today about arbitration. Ken is based in Aberdeen and he's one of Scotland's most respected business dispute lawyers with over 25 years experience advising both UK and international clients. He's a partner here and heads up Brodies International Arbitration practice. He has extensive expertise in dealing with commercial and contractual disputes with a particular focus on oil and gas. Before I hand over to Ken, we're going to run our first poll. The question should appear on your screen shortly. If you would please take a moment to answer it, then we will read out the results. So here's the question. Have you previously had experience of international arbitration? Great, so we have a clear answer here actually. 65% of people are saying no, they haven't, and 35% are saying yes, they have. So Ken, with that feedback in mind, I'm going to hand over to you so you can now tell us all about international arbitration.
Thanks very much, Suzanne. I see that nobody voted by saying they didn't know what international arbitration was, so hopefully I'll be adding something to your knowledge today about the topic. So what we're going to cover is what is international arbitration. We're going to talk about its benefits, how it differs from other forms of dispute resolution, and also the reasons for its increased popularity in recent times. So let's of all deal with the definition. Arbitration is essentially a means of resolving disputes by appointing a suitable third party to provide a legally binding decision. Rather than presenting their cases before a court, parties to a dispute agree to proceed before a private tribunal. Arbitration is a creature of contract, so the parties agree to go to arbitration either when entering into their commercial relationship at the outset by inserting an arbitration clause in their contract, or after a dispute arises, they can agree to go to arbitration by way of a submission agreement. It's an adversarial process, so just as in litigation, parties need to present their cases by way of both evidence and legal arguments. In many ways, the arbitration process is similar to litigation and has been referred to as private sector dispute resolution. An international arbitration is essentially an arbitration between parties in different legal jurisdictions. Obviously, you can get arbitrations in the domestic sphere as well as the international sphere. One of the features of international arbitration that makes it particularly attractive in the international sphere is that you are able to resolve your disputes in a neutral forum and not in someone's home courts. So what are the benefits? Well, this slide shows the main benefits I want to highlight today. There's neutrality of forum, there's flexibility and choice, confidentiality, certainty, cost recoverability, and ease of enforcement. And we'll deal with each of these in turn. So, a neutral forum. Often you find that parties to international agreements might be nervous about litigating before the courts of domicile of their contractual counterparty in the event that a dispute arises. That may be undesirable, and in many cases it might be completely unacceptable to go to the national courts of your counterparty. And you might have concerns in relation to judicial bias. You might be worried about the unreliability of that legal system or how slow it takes to produce judgments. You might be concerned about unpredictability in that there isn't an established jurisprudence of precedents that give you a clear understanding in advance as to how a court would likely deal with the dispute. And the final concern, and possibly the most important one, is whether or not the decision would be enforceable. By selecting international arbitration as the way of resolving your dispute, you are providing for a neutral forum where procedure can be agreed by the parties and you can have confidence in the process. And parties are able to agree in advance features as the procedural rules, the governing law, the makeup of the decision-making tribunal, and the venue for any hearing. Moving on to the second benefit of international arbitration, I would focus on choice and flexibility. Essentially, this means of dispute resolution allows parties to choose exactly how they want their dispute to be resolved. They have a real say in the decision makers, they have a real say in the process. They're not taking an off-the-shelf product that you would have in a litigation forum. And parties are also able to decide whether they want an institution to be involved in the arbitration, either to appoint the decision makers or indeed to handle the arbitration and the administration of it throughout. And there's a plethora of choice as to which institution you might like to have in your arbitration clause. And many of these are well established. So you've got the London Court of International Arbitration, which has been in existence for over 125 years. You've got the International Chamber of Commerce centred in Paris, which again is a very old and venerable institution. And there's lots of other centres across the globe, including, for example, the Scottish Arbitration Centre, which has been opened in the last few years. Parties also get the opportunity to decide in advance the governing law that will apply to the contract, and also the seat of the arbitration. And when we talk about seat of the arbitration, we're not talking about venue or place where the arbitration hearing will occur. We're really talking about what procedural law will govern the arbitration when it's being conducted. And also, of course, the parties can decide the venue, the physical location in which any trial process will take place. You also have choice in relation to who the decision makers are, and that's one key advantage. You're not simply going to have to take whichever judge is allocated to you in a litigation. You're going to be able to pick the decision makers that have the right skill sets to determine your dispute. You'll also be able to decide in your contract whether it's to be one decision maker, 3 or 5. Clearly, you want to avoid an even number so as to not have deadlock. You need to think about how the decision maker is to be selected. Are they to be appointed by an institution, or do the parties each select one arbitrator and those 2 arbitrators that are duly nominated by parties in turn select a chair? And you're also able to provide in the process for what background or specialisms are required of the decision-making tribunal. For example, is it all to be legally qualified people? Is it to be sector specialists, or is it to be a mix? Confidentiality is often cited as an important benefit of arbitration. Obviously, litigation is public, and in England, for example, both the court file and the hearing will usually be open to some level of public access. Now, that could be of concern to you where you don't want your business disputes being covered in the press, or where in particular there's confidential business information you don't want to be disclosed to a wider audience. Yeah, so arbitration is a private process. Confidentiality will cover the existence of the proceedings themselves, the filings in the process, the hearings and the awards. So you're just getting much greater choice as to what level of information is going to be disseminated into the public domain. And now moving on to the next slide, certainty. So litigation in most jurisdictions is subject to an appeal process. And what that can mean is that there can be a lot of delay and a lot of additional cost as the original decision found by a court is possibly going to be overturned or confirmed, and that all takes time. That delays the final outcome, and it also means that the losing party during the dispute retains an element of leverage. Now, arbitration awards are generally not the subject of an appeal, and that means that you can get to the end game, which is an award you're looking to enforce, much more quickly than would otherwise be the case. If we think about the situation in England, if your clause provides for the High Court to determine your dispute, you could be facing 2 rounds of appeals. You could be going to the Court of Appeal, and then in turn you could be going to the Supreme Court. You can cut all of that uncertainty out by simply providing for arbitration with no appeal, or if you choose, appeal only on very, very narrow grounds. Recoverability of costs, again, that's important. So the level of costs that a successful party can expect to recover differs between jurisdictions. Typically in England, you'd expect to recover approximately 2/3 of your costs from the losing party. However, in arbitration, there's a much better cost recovery regime in place, and a successful party in an arbitration can expect to get back much more of their costs from the losing party, and somewhere between 80 and 90% on average. So, enforcement probably is one of the first things you should be thinking about in drafting your dispute resolution clause. You need to decide where you're likely to be having your dispute and whether or not the national courts could enforce that decision in other jurisdictions. So you need to be concerned about whether you're going to be chasing assets globally. And if you're thinking about that, then arbitration has a clear advantage over litigation. They're generally easier to enforce internationally than court judgments. And that's all because of a 1958 New York Convention on the recognition and enforcement of foreign arbitral awards. And that has 161 state signatories to it, which means there's a lot of mutual recognition there, meaning it's relatively seamless to enforce your arbitral award all over the globe. Also, a lot of arbitration laws in national states are based on the UNCITRAL model law, so there's a great deal of consistency in the recognition and enforcement regime worldwide.
Yeah, no, absolutely. I was just wondering whether I could interject at this point and just ask you, in your experience of oil and gas disputes and specifically oil and gas arbitrations, is there a particular forum or venue which is best to use?
I think what you should be thinking about at the outset is what is the likely kind of dispute you might get involved in. And to that extent, there isn't a one-size-fits-all approach to this. If it were me, I would be looking for institutional arbitration rather than ad hoc, so that there's a benefit of an institution like the LCIA or the ICC or some other well-recognized institution that's giving support to the arbitration process. Again, depending on the value of the dispute, you'd be making a decision around whether you want one arbitrator or three. That tends to be the norm. If you were pressing me on what I would choose for UKCS disputes, for example, I would be pointing towards something like the London Court of International Arbitration with 3 arbitrators. But there are other good choices there as well.
Great. So you also mentioned that a lot of the arbitration proceedings are actually offline. Is that as a result of COVID? Is that a development where, you know, I know a lot of litigation processes are now offline, just in an attempt to keep litigation moving. Is that the case in arbitration, or is there another reason for that?
Yeah. So the way arbitrations work actually is largely online. So it's all about filing written submissions, documents, witness statements electronically by email to the arbitration panel and to your counterparty in the dispute. You know, so most of it is dealt with either by electronic filing, same with the discovery process, telephone or video conference where there are procedural hearings. The hearing itself with witnesses, the trial process, would typically be the first time that you are physically in the same room with your opponent and the arbitration panel. But indeed, there's no reason why the online experience with arbitration cannot also extend to the trial process itself. So I think what COVID has highlighted is that arbitration is more resilient than litigation, and that, you know, COVID has not really had a particularly important impact on the arbitration processes. They're still running, whereas a lot of courts have shut down or delayed business because of COVID.
No, absolutely. Okay, well, if I can stop interjecting and let you carry on with the next section, Ken, that would be great.
Okay, so I'm now going to explain a bit about the procedure of arbitration and how it works in practice. So similar to litigation, it is an adversarial process. If you're the claimant, you need to present your case. you'll typically initiate the process by lodging a request for arbitration, and the respondent, your counterparty, will lodge a response to that. If it's an institutional arbitration, there'll typically be a costs advance that's required from both parties, and that will be based on an estimate of the costs of the case or for the first stage of the case. Those costs are payable in equal parts by the parties, but if for any reason your respondent doesn't contribute their cost, then the claimant is going to have to pay that share as well to get the process moving on to the next stage. So what then happens? Well, unlike litigation where you have a state-appointed judge who's got the power of the state behind them to make the decision, you need to appoint, through a contractual process, the tribunal. So you need to get that tribunal convened, whether that's the one person, 3 or 5. And then once they're convened, there'll typically be an initial case management conference at which parties will have the opportunity of setting out what they think should happen in terms of process and how long the process should take. And the outcome of that initial case management conference will be a procedural order which sets out the timeline for the arbitration and the order of events. There will be a written presentation of a case, and that will either adopt the sort of pleading style that we're used to in litigation, where there'll be a couple of rounds of written pleadings at the outset, and the evidence will follow at a later stage in the form of witness statements and evidence being given through witness testimony at trial. Or there can be the memorial style where each party takes a turn to present their case in full, presenting both the pleadings and the evidence at the same time. Disclosure is obviously an important process within arbitration. It's request-based, so typically parties make requests to the other of what types of document they want to recover in the process. And the parties can either agree or object to those requests, setting out the reasons based on relevance or proportionality. Where there is a lack of agreement between the parties on disclosure, it's for the tribunal to determine what documents are to be disclosed. So one of the advantages of arbitration procedurally is that the discovery process is a lot more focused and streamlined than you have in litigation, where you have automatic disclosure processes in England and Wales. And indeed, the arbitration model is being looked at quite carefully by the English court system with a view to potentially adopting it, and it's running a pilot scheme in that regard. However, there are significant opportunities for disclosure in parties presenting their arbitration claims. So it's probably giving you the best of both worlds. So moving on to the next stage, you've had the pleadings, you've had your disclosure, there'll be witness statements that are going to be filed, and then ultimately you're going to have a hearing. Now that can take place online, and we've been involved in online hearings, but certainly pre-COVID, the norm would be to physically assemble at a neutral venue. Again, you've got complete flexibility there, so it doesn't have to be, and wouldn't normally be, some sort of court facility. It could be the offices of a law firm. You could convene in a hotel conference room, just whatever is an appropriate space for the hearing of evidence. It's possible to have written opening submissions that map out your case. Again, there's much greater scope for flexibility. So you can take evidence by video link, and you might choose to do that instead of flying in witnesses from all over the globe. You can have written closing submissions as well, and that can be pretty useful in terms of summating the evidence at the end of the case. What then happens is that the tribunal will need to consider the evidence and issue its award, and the timings for that will vary. But typically, what you can do in the arbitral process is provide for the period of time that the tribunal is allowed to issue its decision. So you've got some certainty there in terms of how long it takes to issue the award.
Brilliant. Thanks, Ken. I'm going to interrupt again, if I may. And you can hear me this time, I hope.
Loud and clear.
Excellent. So I'm just wondering, in general terms, we're just looking there a little bit on the procedure. Is the time it takes for an arbitral award to be delivered comparable with the time it would take for a court decision to be handed down?
I think generally speaking, it's quicker in arbitration to get the award issued to the parties. As I alluded to just a moment ago, you can provide for the timescale in that regard. But also what you've got to bear in mind is that if you're dealing with the litigation forum, then you're at the mercy of how many other cases are on the judicial docket. So if a particular court, a particular judge has a lot of decisions to make, then that's inevitably going to delay the time period for them issuing their judgment. Whereas in arbitration, you are basically paying for 3 private decision makers or 1 private decision maker to decide the issue for you. So you're going to get a quicker turnaround, and you're certainly going to get better certainty on when that award is going to be forthcoming.
And in your experience, how have you found the expertise of the decision makers in arbitration cases compared to court cases?
On the whole, much better. And the reason for that is that parties invest in the process and they're able to select the right kind of decision maker to deal with the dispute. One of the frustrations inevitably with litigation is it is a bit of a roulette wheel as to which judge you're going to be allocated for any particular case. So you might find that somebody who doesn't have the requisite specialism or understanding of the type of contractual dispute you're dealing with, or the industry knowledge, is something that you have to educate the judge during the litigation, and inevitably there's some anxiety there as to whether or not they're going to get the issues. Arbitration, of course, you get to select the decision makers. So to that extent, you've got a real opportunity to get the right intellectual capital embedded into the process at the outset.
Yeah, yes, I have some sympathy with that. Okay, I think you've got a little bit more to tell us about, so I'm going to let you finish off.
Okay, thanks for that. So what are the downsides of arbitration? Well, there are some, and they need to be thought about quite carefully as part of your informed decision making on how you want to resolve your disputes. Tribunals are concerned to ensure that the process is procedurally fair, and they're concerned to ensure that because they want to avoid any situation where the award is set aside at the recognition and enforcement stage, where they have not given fair opportunity to both parties to present their cases. So what that can sometimes mean is that the tribunals split the baby on procedural matters. So if, for example, the claimant wants 2 months for a particular stage and the respondent wants 6 months, you can bet your bottom dollar that the tribunal is going to make a decision somewhere between the 2 and 6 month window. Another downside is that tribunals in arbitration, it can be a highly tactical experience, and by that I mean because there isn't a set of rules that map it out at the beginning. There's a lot of tactics to be employed as to how you present in arbitration and how you go about trying to get what you want procedurally, and that can operate as a challenge. The third bullet point I've referenced is the potential scope for bad behaviour. So what I mean by that is, first of all, in arbitrations, the parties can be represented by non-lawyers who don't necessarily have the same ethical rules that apply to how they conduct cases. And indeed, even where lawyers are employed, if they come from far-flung jurisdictions, they might not necessarily be bound by the same ethical standards as you're used to dealing with, or indeed in some sophisticated jurisdictions, they might be bound by high ethical standards for litigation in their home jurisdiction, but that doesn't necessarily translate into how they are to conduct arbitration. So there can be a bit of an uneven playing field there in terms of the standard of behaviour you can expect from your opponent. There's also guerrilla tactics that are used in international arbitration, for example, where the respondent doesn't engage properly with the tribunal, delays, possibly only turns up for the hearing to cross-examine your experts. So there's a lot more unpredictability there in terms of how the opponent conducts themselves. Greater flexibility and choice, which is a benefit of arbitration, doesn't always necessarily translate into cost benefits as compared with litigation. I mean, one thing I alluded to earlier is that if your respondent does not pony up the money as they go along, as the tribunal requests, then the claimant is simply going to have to pick up the tab. So that's a cash flow downside to arbitration. However, the flip side of that is that if you win the arbitration, you're going to get much better cost recovery than you would in a litigation. And I think the final downside I'll mention is the absence of any default award in arbitration. So in litigation, if your opponent does not enter appearance, fails to file a defence, or otherwise doesn't meet a procedural requirement of the litigation, the court is empowered to issue a default judgment against that party without investigating the merits of the case. There isn't a default system in arbitration, and what you're required to do is set out your stall and demonstrate to the arbitrators that you are entitled on the merits to the award that you seek. What I would say, however, is that if there isn't any engagement from your respondent in an arbitration, I wouldn't expect the matter to proceed to a full civil trial with witness testimony. I think it could be dealt with on a documents-only basis with the lodging of sworn witness statements. So moving on to the last point, and that's to talk about the increasing popularity of international arbitration. So I've listed a number of bullet points here as to why I think international arbitration is becoming more popular. First of all, international commerce is, COVID aside, on the increase, and inevitably where you have an international dimension to the contracts that you're entering into, there's going to be a desire to move away from national courts and to have disputes resolved in a neutral forum. I think secondly, there's an element of litigation fatigue. I think that a lot of sophisticated parties are no longer buying into the concept of being embroiled in litigation for a long period of time, with the inevitable appeals that can be filed and all that goes with it. And I think that just general tiredness with the public sector dispute resolution offering through the courts is a reason why private sector approach might be preferred. I think thirdly, there's an increased awareness of arbitration and international arbitration. There's a big international conference due to be in Edinburgh in 2021 that will promote awareness. I think as people become more aware of the options as to how to resolve their disputes, they are applying more thought to that, and international arbitration and its benefits will come to the fore. I think political factors will have an impact on the development of international arbitration. Certainly if there's political instability in nation states, then that's a good reason for not going to their national courts. I think as well with political forces such as Brexit, such as a potential second Scottish independent referendum, there's more attractiveness in moving away from national courts to the neutral platform that international arbitration can offer. And finally, I think that there's been, on the supply side of all of this, there's been a lot more centres of international arbitration set up all over the globe. So what you're finding is that a lot of countries are getting in on the act here and setting up their own arbitration centres with a view to attracting business away from the national courts, and indeed competing with each other to offer something different for parties who want to resolve their disputes.
Thanks, Ken. So if I may, I'm just going to come back to some questions that have come in. First one is, can consultant communications between it and its client leading up to the submission of pleadings be kept privileged? I know there is legal privilege, but not sure of consultant privilege once lawyers are on board.
Well, I think the key thing about legal privilege is to ensure that ideally to involve lawyers as soon as possible in the process, because typically you will get legal privilege where there is client attorney advice, or where steps are being taken in contemplation of litigation. So legal privilege is a topic in its own right. There isn't any reason why privilege doesn't extend to contemplated arbitral proceedings. And therefore, the advice that we would give you in relation to how to ensure communications are legally privileged in the run-up to an arbitration or any kind of dispute would be exactly the same as to what we would advise you if we were thinking about a litigation. So, it's probably beyond the scope of this presentation to go into that in too much detail, but some of the key things would be to ensure that the group that's been disseminated with the information you want to keep legally privileged and confidential is kept as small and tight as possible, and obviously mark those communications as privileged and confidential, again, would be a good tip.
Yeah, great. We've learned about a lot of the advantages of arbitration today. Are the costs incurred in undertaking an arbitration comparable with those in a court case? I know you've touched on costs in a couple of points in this seminar, but I wonder whether you could just kind of summarize that.
Yeah, and I think it's, it's horses for courses, really. I mean, some arbitrations are going to be, a well-managed arbitration should be cheaper than a litigation. But obviously that requires both counterparties to the dispute to engage properly and meaningfully in the process. Obviously there are some initial costs up front with arbitration that you don't have in litigation. You've got to assemble the tribunal. You might have an arbitral institution whose costs you've got to meet, and so on and so forth. But I think there's real cost benefits, and also a lot of indirect benefits in terms of cost as well, in terms of the predictability of the arbitration timetable is much better. So it's very difficult to persuade arbitrators to depart from a timetable once it's agreed. Whereas in litigation, it's often the case that things are put off because at the last minute, somebody wants to amend their case or put forward a new position. So there's less tolerance to that in arbitration, which means that on the whole, arbitrations, if they're well run and organized, will be cheaper. But in fairness, plenty of arbitrations will be just as expensive as litigation. Again, it really comes down to the type of dispute and how the parties are engaging in the process with the tribunal.
Okay, thank you. That's really helpful. Obviously, we couldn't get through our webinar without mentioning Brexit. So turning to Brexit and the possibility of maybe facing a no-deal situation, and in light of the ongoing COVID situation, it seems likely that there is going to be an increase in disputes, in the level of disputes. Do you consider that there will be an increased role for arbitration to play in the context of disputes going forward?
So first of all, I absolutely agree with Brexit and with the ongoing impact of COVID-19. There will be more disputes, and therefore arbitration will be grabbing more disputes and probably a bigger market share of those disputes. I think that one of the challenges that we have with litigation is that courts have not necessarily adapted well in terms of COVID and the technological changes required of them. Because most of what is done in the arbitration process is online, then it's a lot more resilient to pandemics and disruptions of that kind. So I think what people are going to find is there's a big backlog of cases that have to work their way through the public sector court system, and that's going to turn a lot of people towards international arbitration, where they're going to get their disputes resolved more quickly.
That's interesting. And another question that's come in, do you have any tips for drafting arbitration clauses?
Plenty of tips, which I'd be happy to discuss with anyone who wants to follow up on that. I think the key things about an arbitration clause is clarity as to what you are looking to do. You want a clause that is workable. In other words, it's capable of being enforced. That's got to be the minimum standard. But you've got to also have a clause that's right for the parties to the contract and the anticipated disputes. So I think you need to think very carefully about the number of decision makers, how they're to be appointed. Do you want an institution supporting the arbitration process just for the appointment of the arbitrators or throughout the process? Do you want it on an ad hoc basis? What seat should the arbitration be based in? There are a huge number of questions there to be thought about, as well as, you know, a huge number of international arbitration institutions to consider selecting in your arbitration clause. So I think the most important thing is that you apply a lot of thought to that. I think you want, as a minimum, to be saying how many decision makers, how they are to be appointed. Think about the default position if there's not cooperation in the parties appointing the decision maker. You need a third party to appoint the decision maker in that situation. You must set out what the seat of the arbitration is going to be. And there are lots of other things that are desirable to put into an arbitration clause. I think the more you get into thinking about arbitrations and the type of provision you want, the more questions you will have, and the better informed you'll be in terms of deciding what clause is going to be right for your contract.
And what about if you have a contract, an existing contract that doesn't have an arbitration clause in it? Is all lost? You know, have you?
Yeah, no, not at all. I mean, as I kind of alluded to earlier, it's possible to go to arbitration either because you've got a clause to that effect in your original contract, or after a dispute arises, it's possible for the parties to the dispute to agree to go to arbitration and just enter into a contract to that effect, rather than go to whatever the contract provides for. The advantage of dealing with going to arbitration after a dispute has arisen is you can obviously then get the best bespoke outcome in terms of how that's to resolve. The challenge you've got after a dispute arises is you are relying on your counterparty to cooperate, and if they're not minded to, then you're just going to end up with whatever the contract originally provided for.
Yeah, obviously that's difficult when you're in a dispute scenario already. I think we probably have time for one more question. Most of the oil and gas contracts are governed by English law. What are your views on having an institution involved in a dispute? And if one is involved, which one?
Right. Okay. Well, first of all, I mean, I think as a generality, if you're dealing with higher value disputes, then it's good to have an institution involved. They've been dealing with the administration of international arbitrations for a long period of time. So you'll get a lot of institutional knowledge there that will be beneficial to your process. And that's worth paying a little bit more for. The institution will also be able to support the arbitrators in terms of how they go about their business. And that's a good thing as well, because you want your arbitrators just focusing on your case, and you don't really want them getting bogged down in the administrative processes. So I'm certainly in favour of institutional arbitration when it comes to oil and gas sector disputes. As to which forum you should use by way of an international arbitration dispute centre, I think that depends on the geography of the economic activity. So if, for example, you're doing activity in the Far East, you should seriously consider Singapore as a dispute resolution centre. Hong Kong also has a really good reputation, though of course there are political turmoils in Hong Kong at the moment, and Singapore is certainly looking to grab more market share from Hong Kong. If you're talking about UKCS, Mediterranean work, Atlantic work, you know, I don't think you can go far wrong with looking at the London Court of International Arbitration, or in the alternative, the ICC. I think the main thing is that you're applying specific thought to it, and you're going with a well-recognised institution that is just professional in how it goes about conducting its business.
Okay, thank you. That's really helpful. I think, Ken, that's probably just about all we have time for today. Thank you very much for presenting. I found that really interesting. As far as everybody concerned who is watching this webinar, you should receive a survey request at the end of the session. Please do complete it, especially if you have any topics which you would like us to cover in future sessions. So I think that really brings today's session to a close. I'd like to thank you all for joining Ken and I today. We hope you found that useful. And we look forward to seeing you all again when we kick off with our autumn-winter series later this year. Thank you all very much.